investigation, which came with the evidence of BBS, who testified that he is the biological elder brother of the accused person. He said that in 2020, he got information that his brother was admitted in Butabika. When he went to check on him in January 2020, he learned that he had been admitted following an incident that had happened. Counsel for the accused did not lead this witness to explain to the court what incident it was. He further testified that he learned from the medical staff at Butabika that he was being held there because of what had happened, but they did not give him reasons. He further testified that he was not certain of how long he had been at Butabika, but he had tried looking for him in December 2019, and they said that they could not discuss any details with him, despite the fact that he had informed them that he was his brother. It was at this point that Mr. Kumbuga Richard, counsel for the accused person, made an application to this court while relying on Article 28 of the Constitution, that's the right to a fair hearing, and Section 46(1) of the Trial on Indictments Act. He asked the court to call the doctors in Butabika because from the evidence on record by the prosecution, it was indicated that the accused had a history of mental illness. He also asked this court to make an inquiry into the mental health of the accused pursuant to Section 46(1) of the Trial on Indictments Act. He further stated that this government institution, that is Butabika, would be in a position to tell us whether the accused has ever been in Butabika in his life and his health status, and they will also be able to tell us whether following the proceedings and to be put on his stand matters he has finished. I need to observe from the onset that I find this application in the middle of the testimony of DW2 with almost no background information, very irregular. I would rather counsel waited for the witness to first give his evidence, whereupon he would have sufficient information upon which to base his application. Nevertheless, I will proceed to address his concerns. In reply, Mr. Jonathan Muwaganya, Chief State Attorney, while citing Section 46(1) of the Trial on Indictments Act, contended that this application is rather strange and was brought too late. He argued that the provision of the law, that is Section 46(1) of the Trial on Indictments Act, relates to the capacity of the accused person to follow proceedings during trial. He argued that an application under this section should be brought before the accused's defense and not after. While citing the case of Omaka Geoffrey versus Uganda, number 9 of 2017, he submitted that the capacity to stand trial when the person has capacity to stand trial when he is able to do one or more of the following. A, that he understands the nature and consequences of the proceedings, and that he can communicate with his advocate in the sense that he is able to take part in his own defense. He further argued that the two separate questions to ask is whether the accused is able to understand and plead to the indictment against him, and whether he would be able to take an effective part in the trial. He further stated that this was for courts to decide and not the doctors. That is from that decision. And now this is the decision of the court. Section 46 of the Trial on Indictments Act is under Part 7, which provides for procedure in case of mental illness or other incapacity of the accused person. Subsection 1 thereof provides that, and I'm quoting, when in the course of a trial, the High Court has reason to believe that the accused is suffering from mental illness and consequently incapable of making his or her defense, it shall inquire into the fact of such mental illness. In the case of Omaka Geoffrey versus Uganda, which the prosecution relied on, I am persuaded by the decision of the Land Honorable Justice Stephen Mubiru regarding what to look at when to determine whether a person is capable or not. He says a person will be capable of standing trial where he is able to do one or more of the following: understand the nature or object of the proceedings in the sense that he is able to understand that he is in a courtroom, recognize the people in the courtroom, that is, the judge, the state attorney, his advocate, and why they are there. 2, understand the possible consequences of the proceedings. That is, to understand what he is charged with, what kind of pleas he can take, that is, guilty or not guilty, what can happen to him if he pleads guilty, or what can happen if he does not tell the truth in court. 3, communicate with his advocate in the sense that he is able to take part in his own defense and tell his advocate, even in best terms, what he wants to do with his case. When this matter first came up on the 13th of April 2026, this court interfaced with the accused person for the first time. I extended my greetings to him and he respectfully responded to me. I informed him that there were some charges against him and I needed to tell him his right to a fair hearing under Article 28 of the Constitution. I explained to him his right to a presumption of innocence and the right to be legally represented, among others. I informed him that 2 lawyers had been assigned to him to assist him in these proceedings. I also informed him that if he had anything to ask or communicate, he would communicate the same through his lawyers or he would speak to the court directly. I then asked him if he had understood and he answered in the affirmative. Since then, the accused person has very well exercised those rights, right from the time of taking plea to the time of giving his defense. The accused exercised his right to plead not guilty to all the 4 counts, and in fact, when I first asked him, while explaining to him the particulars of the first count, and I asked him whether it was true, he asked me, "Do you mean my plea?" And when I said yes, he went ahead to say, "I plead not guilty." This pattern followed through the other counts. I have observed him throughout the proceedings, and I am satisfied that he was alert and keenly following the proceedings. Occasionally, whenever he had something to communicate, he often raised his hand, and I would either ask his lawyers to attend to him, and immediately I would ask the lawyers whether they had a communication to make to court from the accused person. However, on other occasions, he raised his hand, and his lawyers would tell me that he wants to address court personally. Whenever I gave him a chance to speak, I did not find anything irregular with his speech, which would have given me reason to believe that he is suffering from mental illness and incapable of following the court proceedings and eventually give his defense. When the prosecution closed its case yesterday, the 23rd of April 2026, and after finding a prima facie case against the accused on all the 4 counts, thereby requiring him to give his defense, I explained to him the options that were available to him to make his defense pursuant to Section 74, subsection 2 of the Trial on Indictments Act. I then asked him if he had understood, and he said that he had understood. I specifically asked the accused person to repeat what he had understood, and he accurately explained it back to me. I gave him 30 minutes to consult with his lawyers and informed the court which option he would take. When court resumed, he informed the court that he wasn't quite ready, but said he would give a sworn testimony. Regarding his witnesses, he informed the court that he needed to get their particulars in his 3 phones, 2 smartphones and 1 button phone, which he clearly described. The same which were already admitted as prosecution exhibits were availed to him, and he was given time to scroll through them, upon which he wrote 4 names and telephone contacts on a piece of paper for court to summon them. I am glad to note that the defense has informed the court that 2 out of the 4 witnesses whose particulars were availed to court were duly summoned and are present in court. The current witness, BW2, who stated that his accused brother being one of them. After the accused informed the court that he would give a sworn testimony, I again gave him an hour to prepare himself. And when court resumed, he still informed the court that he was still not yet prepared to give his defense. I then reminded him that if he gave a sworn testimony, he would be subjected to cross-examination by counsel for the state. And then he responded, in that case, I will give an unsworn statement. The matter was then adjourned today, the 24th day of April 2026, when he gave a detailed and sworn statement. The accused asked whether he could consult his notes while he gave his defense, and his request was granted. He then took out his notes and kept on making reference to them under different subjects. He also occasionally made reference to the evidence of the prosecution and going ahead to rebut it with his own evidence. He repeatedly stated that he did not deliberately kill the 4 children, but he was under the control of some people whom he said were in 3 categories. The accused further stated that between the months of January to March this year, he was in distress as a result of those people who were surveilling him, and he understood that they would prevail over him. I am satisfied that this is his defense, which the court will analyze in light of the other evidence on record at the time of giving judgment. Throughout the trial, it has been, of course, clearly said that the accused person suffers from chronic sickle cell anemia disease, which affects his body. It does not affect his mental abilities. In light of the above, therefore, in the course of this trial, I have had no reason to believe that the accused is suffering from any mental illness, which would make him incapable of making his defense, thus requiring me to inquire into his mental abilities. I have watched the accused throughout the trial, and I'm satisfied that he has been following the proceedings right from the beginning. I therefore decline to make an inquiry into the mental health of the accused person as requested by his lawyers. Counsel for the accused has also asked this court to call the doctors in Butabika. Unfortunately, he did not specify which doctor this court should call. He also stated that the doctor should tell us whether the accused has ever been to Butabika Mental Hospital. Unfortunately, he also did not specify which period. It is important to note that BW2 is the first person to mention that the accused person has ever been in Butabika. The accused person himself, while giving his defense, never mentioned at all that he had ever been in Butabika. The mental distress he talked about while giving his evidence was between the months of January to March 2026. Counsel for the accused made reference to PF24, which was marked as a prosecution exhibit PEX7. That was the examination of the accused person on his physical and mental abilities done on the 7th of April. Those were five days after the alleged offense happened, by Dr. Nwamaya Emmanuel, who is a police surgeon but also a psychiatrist. He informed the court that he assessed the accused person, and these were his findings, and I'm quoting. He had normal behavior, calm, cooperative, speech was coherent, his memory intact, and exhibited good judgment. His thought process and content was normal, but believed in wealth by human sacrifice. He was able to explain the reason for killing the children as fortune hunting or enrichment. He got the idea on recalling childhood folk tales of getting wealth by sacrificing people. In that report, Dr. Nwamanya made a note as information from the accused, and I'm also quoting. He had a history of past mental illness, treated between 2016 to 2025 for schizophrenia associated with both auditory and visual hallucinations. He killed his 2 to 3-year-old brother in 2016 or 2017, reportedly to save him from the troubles of this world. He also attempted suicide in 2023, and he was also a sickle cell patient on treatment. The findings above are suggestive of a mental condition with psychotic episodes. Further mental assessment is necessary since no medical documents were availed and was the only source of information. From the above information, Butabika is not mentioned anywhere. The defense has not given this court any information regarding the mental health of the accused person in light of the presumption of sanity under Section 10 of the Penal Code Act, Cap 128. Having said that, I reiterate that the only person that has mentioned that the accused person has ever been to Butabika before this court is DW2. I am unable to make an order requested for by the defense lawyers on behalf of the accused to call a doctor from Butabika before hearing the full testimony of DW2. In the meantime, DW2 shall continue his testimony, whereupon the court will make a decision as whether it is necessary to call somebody from Butabika or not, but it will only be restricted to as to whether the accused person has ever been to Butabika, but not make an inquiry as to whether he is capable of standing his trial. And that is the order of the court. Can give the summary.
Twawumulidde